Hi, it's Mark Marmer from Signature Electric in Toronto. So there's been a lot of changes to the Condo Act over the last years or so, and a lot of them haven't had a lot to do with us. But now the government has seen an opportunity that the changes in the Condo Act and the new adoption of electric vehicles to make some changes and hopefully help with the adoption of these electric vehicles, particularly in existing buildings. So because it's sort of a legal end to it, we reached out to somebody in the industry, and I've got Denise Lash from Lash Condo Law on the phone, and she's going to help to sort of guide us through what these changes. How are you doing?
Okay, hi Mark. So you're right. There's been a lot of changes in the condominium world, and we first heard about changes to electric vehicle charging station legislation quite a few months ago, and the ministry was asking for our feedback. Various individuals that are active in the industry to advise them as to whether we thought certain provisions that they were proposing were a good idea. And so we did give them feedback, and they did change things.
Right, and I remember responding to that feedback, and I remember it being quite a long laundry list, and I think probably both you and I were worried about something in there, whether it may not have been the same thing. And in the end, once the exemptions came down, they came down to be much more pared down. Is that sort of that your feeling as well?
Yeah, and I think it's a lot better. So the one concern we had is, and you know how many, there are probably around 11,000 condominium corporations in Ontario. And one of the proposed changes was that electric vehicle charging stations and systems were going to be required for every condominium, every one of those 11,000 condominium corporations.
Mm-hmm.
And, there are some buildings that really don't need it. There's, older buildings, some of them do, would like it, but really it should be left up to, this is my opinion, it should be left up to the boards, the condominium corporations to decide whether they want it or not.
Absolutely
And
agreed. Yeah.
right. So that was, and I think they must have heard your feedback too, as well as others. So they scrapped that one. So now it's broken down into two categories, and that is, installations that the condominium corporation wants to put in for its owners, and the other is requests from owners that want it. And so they've really set out what the requirements are. Now, you have to keep in mind that we've been dealing with this for a number of years. As soon as electric cars became sort of more available to the consumer, and other electric vehicles, so not just cars. And so there have been requests by owners to condo corporations, and they have been allowing them in certain circumstances. But there was always the question as to how you do it, and there's no regulation around it. So I think this is a great thing. So it's now a separate procedure, follows separate rules, and it's going to be right in the Condominium Act. And so I think it's a good thing.
That's great. You know what? You're right. We've been at this for about 5 years now. We've got quite a few installed in condominiums, and it hasn't always been a perfect and easy arrangement in terms of managing through the legal part of it as well, and exactly how we were going to do it. So moving forward, we'll certainly, as Signature Electric, we'll have ideas on how to better help condominium corporations have a proper means of sort of assessing from day one before they even put in the first charger. I know there were a couple of changes. One of them had to do with Section 97. So any chance that you could just sort of give me an idea of what Section 97 kind of is? Because some of it I know and some of it I don't know, but maybe just a little background, and then we could just get an idea of how that's going to simplify things for people.
Yeah, so Section 97 applies mostly to condominium corporations, and Section 98 is the one that deals with unit owners. So 97 deals with alterations to the common elements and steps that the corporation has to take if they alter the common elements. So putting in EV stations and systems could be considered an alteration to the common elements. So there's a procedure that you follow. So what this new legislation says is you don't have to follow that procedure. We have our own procedure. And it makes it a lot easier. It sets out the steps the corporation has to take. And if the board feels that, in their opinion, that it would not cause a material reduction or elimination of all the unit owners' use and enjoyment of the common elements, and it's not greater than 10% of the budget, then they can go ahead and do it. So, if they had to comply with 97, and I won't go into all those rules, but it makes it more difficult. So the reason we have this legislation is to make it easier for condominium corporations, and the board will decide to do this because, it does benefit the community. And then for owners wanting to do it.
Let me hang on just before we move on to section 98, because I'll get lost because I just had a couple more questions about 97.
Sure.
So we're talking about, it sounds to me like we're talking about what might be what we call a community charger, something that might be put in a visitor's parking space that people can use that, might have cost $15,000 or something, just to throw out a number. It sounds to me like, number one, they could have done that before. The number didn't sound so large that it didn't interfere with section 97 to begin with. Am I correct or wrong?
Yeah, so unless the cost was, if the cost was between 1% and under 10% of their annual budget, and I don't know what it costs, I guess you would know, would it be under 1% of a budget, or would it be over 1%?
I mean, I guess every corporation is different, right? I don't know what 1% of somebody's budget is, but I would think that normally it would have been under. I suppose it depends if you were putting a whole system of transformers and everything else in. You might at some point reach a point where you're thinking, oh, well, maybe this is over 1%. It's hard to say,
so
right?
If it's over 1%, the way it is now, is that you have to give notice to the owners, and the owners, it can get 15% of the owners to call a meeting, and they could vote against it.
Right.
So
it also talks about. Oh, sorry. Yeah. I'm sorry. Go ahead.
No. So with this new legislation, if it's under 10%, you send notice, but it doesn't give the ability of the owners to call a meeting to vote against it. So it's a big difference.
Okay. It mentioned reduction in use. So I'm wondering if I said, okay, well, the corporation's decided they're going to take 2 of these visitors parking spaces, they're going to put charging stations in there, and that will be maybe hopefully for electric vehicles. Could somebody come back and say, well, hold on, that is a reduction in use. Those spaces were always available for everybody, and now you're making them only for electric vehicles. When my gasoline vehicle comes and you're going to dissuade me from parking there, and now I've lost 2 of my visitors parking spaces. Would you think that would be a fair argument to make?
I think it would be a fair argument. So the question is, if you put these electric vehicle stations in visitor spots, do you prohibit other cars from parking there? And that is an argument. It's got to cause a material reduction or elimination, use of enjoyment of and in that case, it would be of a common element. And that's, that would be up to the owner to make that argument. And and then we may have new litigation. There's always.
It all depends. This is just sort of going to unroll depending on how it unrolls, and we won't know until it gets tested like other laws. Is that the idea?
That's exactly it. We're now dealing with this issue, and we're dealing with marijuana at the same time. I mean, we've got all these new laws that are coming into place, and we're not sure how they're going to work and how it's going to be implemented, and what owners will do. So right now, the board will make the determination as to whether that's a material reduction or not.
Interesting. Okay, so section 98 I know a little bit more about, because pretty much every time we go to put a charger into what ends up being the common element, the person's parking space, or it's a shared common element, or change to this. I'm not quite sure what the wording is. I know that we've had to have an alteration agreement, a Section 98 alteration agreement, which typically the resident has had to pay for. So it sounds like we're now waiving the need for this Section 98 agreement. But I must tell you that when I read the wording, it says, okay, you don't need a Section 98, but you need to do this and this. You need a drawing, you need this, and you need that, and you need to submit all this stuff. And I'm thinking, submit to who? Because if ultimately I take it back to the office and the office goes, well, I don't really understand any of this, I'm going to call my lawyer, and I have a charge to call my lawyer. I don't understand where I saved any money. I'm a little lost in the wording, because it didn't just say once you do this, we're okay to go. And and from an owner's perspective, I'm not an owner of a unit, but we deal with them all the time. We end up with, even when you guys are trying to do the best you can, the bill ends up being $1,000 or $1,200 or whatever the case is to sort of manage this, and it's another $1,200 on top of it. Costs this much to install it, and it costs this much for my station, and I'm beginning to wonder whether I'm even saving anything in my car because I have all these expenses. I think this was a response to that, and I'm concerned that the way the wording is, it may not actually save any money.
I think you're 100% correct. And when I saw the way this legislation has now been changed and drafted, it's pretty much the same process. It makes it easier for owners, but it's the same process for applying for an alteration. So you have to do an agreement. They're not calling it a Section 98 agreement.
Mm-hmm.
It has to be registered on title. That's what it looks like from here.
Mm-hmm.
And it has to contain the same provisions as a Section 98. So yeah, it's not called a Section 98. It doesn't fall under Section 98 of the agreement, but it falls under another provision, and it's essentially the same. And in fact, about an hour ago, I got a call from a condominium manager wanting to know about these rules and saying, we have an owner that's applied for it. Now you have to do this agreement. What's it going to cost? Is it going to be the same as a Section 98 agreement? I said, well, I now have to draft one from scratch, but the more I read about this, it looks like exactly the same. So little changes. So I think the costs are going to be pretty much the same. Maybe the first one will be more expensive because it's now a new kind of form and a new kind of agreement. So little different provisions, but essentially the same. I mean, the one change here is that, like Section 98 agreement, so if an owner wants to do an alteration to the common elements, the board can flatly refuse. They could just, in their discretion, say, no way, we don't want it.
They could have before.
They could before. Now you can't. Now, the board has to have a reason, and the reasons are set out in the legislation. So they have to approve EV stations by owners, unless by installing it would be contrary to some legislation or, the declaration, that for some reason, like it's where it's installed contravenes building code, or, if there was something fire code issues, that's sort of the only way, or somehow it will adversely affect sort of the structural integrity of the property.
Mm-hmm.
So if it doesn't, that the owners, the condominium board will have to approve it. So, I mean, that's a good thing for owners. The only concern I have is, and you would know this, I mean, there are certain circumstances in which it cannot be installed, right? Or there's certain capacity.
Well, this is exactly one of the places I wanted to. This is our stuff, so I know about this, and I say, okay, so it looks like saying that there's not enough power or whatever, that's not an answer. Except that is an answer, because when we go into a building to talk about electric vehicle charging, the first thing we do is a load evaluation. In other words, I have this big of a service. I'm using this much to operate the building now for the last year. I have this much left over, and of that amount, I'm comfortable to be able to use this to serve these electric vehicles. Well, there's a finite number that I'm going to reach, and it probably is not. The number probably doesn't equal the full number of parking spaces in the building. So when I reach that finite number, upgrading the service is not a reasonable thing. It's not something that it truly just can't be done, and we'll have to work as best we can within that. But it sounded to me like, well, maybe that's not the answer.
Well, so that's exactly what the legislation doesn't say. It doesn't allow the board to say, we've reached our capacity, we can't add anymore. It sort of says that you have to, unless, I guess the argument in that case would be that it's contrary to the electrical safety code, or I mean, I don't know.
I don't know either. I guess we'd have to see when we get there. But I mean, I don't think any reasonable person's going to ask a building to. I mean, the upgrading of service is not like at your house where we, $3,000 and we now have a 200 amp service and a 100 amp service. It's just not. I think ultimately, it's probably physically not possible. The rooms were built with a certain size and what have you.
Well,
you know what?
What would it cost if you had to do it?
I don't think cost even enters into it, because when the building was built, the equipment was the physical spaces where the electrical rooms went. They were sized to allow for this equipment to come in. So if I had to bring bigger equipment, so if I had a 2,000 amp service, but I wanted a 4,000 amp service, so you get the idea. It's twice the size of what the other one was. Where's that equipment going to go? Where am I putting that to feed this? It's just not. I don't think it's practical at all. I'm hoping we'll come up with solutions that won't require this, but it caught my eye that they, it's not a reasonable thing to say. And then maybe we starting to talk about things like structural integrity at that point. I think, screwing a bit of conduit to the wall is not a problem. But now we're talking about, okay, well, now I have to blow out these walls and stuff. And now we are talking about something else. And, hopefully I'm glad to see the adoption of electric vehicles, but hopefully this will not be a problem that's going to arise. We'll see for each other. But I don't think it's a question of cost. That's another thing. They talk about the owner paying the cost. So I absolutely get it. If there's an electrical panel, there's some conduit to go, and there's a charger to go into your space, I don't think there's any question that we understood that you were going to pay for that cost, just like you would in your house, from the panel out to your garage and whatever. But what I get from the board sometimes is, oh, you know what? There's a $15,000 transformer and panel that I need to put in. You can pay for that cost too. I said, well, no, that panel's big enough to accommodate 10 or 12. Well, who's going to pay for it? They say. So it wasn't clear in this about cost. Which cost are we talking about here? And we do get these kind of what I think is sort of not very imaginative, maybe a little silly responses from the boards. Not all of them. Most of them are pretty good, I must tell you. But occasionally you get this kind of thing,
Well, I guess that's the question. When the first owner requests it, and if they're the only one requesting it, and you have to install this panel, I guess you could argue that it's that unit owner's cost. Maybe when you get other owners after that, maybe there's a way to reimburse that first owner for a portion of that. I mean, it's a suggestion.
Right, for sure. What we normally do, and what we do in our seminars and what have you, is we talk about policy. So we talk about the idea of, don't think about this one owner. I want you to think the whole thing through from the beginning to the end. What's the plan going to be? How are we going to handle this in our corporation? What's the expectation that not only, Unit 115 is going to have, but Unit 205? I want everybody to be treated the same and to have the same thing, and to be able and to be able to share the resources best we can, that electricity that we're talking about, and keep the billing organized and what have you. So that's kind of where we go. Hopefully that's just going to work, but it sounded to me like some of this stuff is still ambiguous. I want to ask another question because it's really important. It didn't sound to me like I had to. Right now, it's pretty clear. If you need a charger and you have a deeded space 115 in the garage, that's where your charger is going to go, because that's your deeded space. But it sounded to me like maybe when I accommodate you, if I could accommodate you in a different space, that could be an accommodation that might be considered acceptable. So I could say to you, we have this EV charging area. All our EV chargers go together in this space over here. We can accommodate you. You just have to move your car from here to be here. You may have to swap spaces with this person and that person. This, from our perspective, an electrical perspective, would make things enormously more easy. And I know that it was on the that the government had this on their agenda originally and it didn't end up over here. Do you think that's actually a possibility or not?
Yeah, I mean, that's one of the questions I had because it does say that the corporation may require the installation to be carried out in an alternative location. Um, that and it says what it says there is if that location, again, that term would not cause material reduction or elimination or use of their enjoyment of their units or common elements. So I guess if they move the spot to an area which it, is very inconvenient, I don't know what that would be. Maybe that owner can refuse that to do that. But yeah, that's a big question mark. I mean,
This
you're
is like
sort
a
of
really
highlighting the problems that I see in the wording of this legislation. How does that work? Like, how do you move someone to another spot that's, if it's a visitor spot, it should only be used for visitors. If it's somebody else's spot, how do you force them? Unless it's in a declaration that you must switch spots with somebody else, which was the original legislation that they had proposed. They took that out. Then
that's too bad. My perspective, that's too bad.
So I don't know how they could specify another location, how that would work. Because if an owner owns their parking unit, so now are you giving them a common element? And how do you do that without depriving others of that space? Like, you can't just take someone's parking unit and say, okay, everybody can use that parking unit, and then give somebody who owns a parking unit part of the common elements.
I'll tell you what I would have liked to have done, and you tell me if you think this is actually realistic. I would have liked to have the charging in the worst possible spaces in the building. So all the way down to the bottom of the P3 level, against the last space against the wall. Start my first station there. So and start moving back. So what happens is if I switch spaces with somebody, if I had that last space, I would have the worst space in the building now. So no matter what space I move to, I'll be moving to a better space. The person who needs charging will now have a place to charge. They may have to drive down a couple of more levels, but they actually will be accommodated and have a space to park. This is a type of scenario that we use in other locations. It's just that we have what I understand to be literally deeded parking spaces. It seems to me, if I'm understanding correctly, it's the equivalent of me wanting to sell my apartment and move from the second floor to the 14th floor.
Mm-hmm. Yeah.
I'm right, huh?
Yeah, I agree. So, I think what we're going to have to do is wait to see how this plays out. And there will be questions and we'll be giving opinions on this. And I'm sure you'll get different opinions from different condo lawyers on the subject. So, we don't know, but you've highlighted exactly the areas that I was focusing on as that may not be so clear.
That's great. You know what? First of all, I know that when I asked you originally, you told me you're swamped with stuff with the Condo Act, and I know you and all the other lawyers are. So, first of all, I really appreciate your taking the time to talk to me about this. My takeaway is that we're going to have to wait and see how some of these things test out, and hopefully it's going to be good. I think the one thing for sure that came out of this is good is what we tend to call the right to charge, this 60-day period. In other words, simply saying no and no other words, that's gone by the wayside, and I'm happy to see that. So I think that's the biggest takeaway for me for this whole thing. I'd like to take just a second for you to tell the listeners and the people that are here, because I just barely said your name at the beginning, just a little bit about Lash Condo Law, and do maybe just a tiny intro for yourself so that we know who you are, and if people are looking for advice on this or something else related to a condo, that they would know how to reach you. How about that?
Oh, that's great. Yeah, so Lash Condo Law, we're a small boutique law firm in downtown Toronto. I've been practicing condo law and I've seen all kinds of issues over the past 26 years, always something very exciting, always new legislation. We've got a website. We also have a blog. So we blog, and you probably saw my electric vehicle charging blog.
Mm-hmm.
Yeah, we do that every week. So we do like subscribers, and people love our blog. So it's lashcondolaw.com. You could sign up right on our website as a subscriber. We also have like useful guides for condo directors, owners, or managers. We've got the Condominium Act there, so it's a resource as well. And then there's also a description of our team and the work that we do. So it's a very interesting time for us, and we're very busy these days.
Good. I'm thrilled to hear that you're busy. I really appreciate the time. We also have a blog. We're Signature Electric. We're located in the Greater Toronto area. We are a full service electrical contractor, but a lot of this sort of the confluence of our connection with condominiums and electric vehicles has sort of positioned us to be quite knowledgeable about this, and we're working to try to help these condos. You're working on the legal end, and I'm working sometimes on the mechanical end of it to figure out how we can make this all work. So people looking for us can find us in the Toronto area. They can call us 416-490-8093, or they can come to our website. Again, we have a very similar idea, lots of information at signatureelectric.ca. Denise, thank you so much. I'm going to let you get back to work, and I'm going to get back to work, and I'm sure our paths are going to cross again very shortly.
Definitely. Thanks, Mark.
My pleasure. Bye-bye.
Bye.